By now, everyone here has heard that the Supreme Court ruled that corporations can fire women who use birth control and that religion trumps all other values in constitutional discourse. At least that's what my Twitter feed told me when the Supreme Court decision in Burwell v. Hobby Lobby came down. Actually, what was at stake with the case had nothing to do with the power of big business, the freedom to use any kind of contraceptive, or how to balance religious liberty against other constitutional concerns. Hobby Lobby was actually a straightforward question of statutory interpretation regarding whether the government was justified in this particular case in overriding religious liberties. The Supreme Court ruled, as Roger said, that closely held corporations can't be forced to pay for all of their employees' contraceptives if doing so would violate their religious beliefs. So there was no constitutional decision, no expansion of corporate rights, and no weighing of religion versus the right to use birth control. But let's unpack that. Let's step back for a second. So the Department of Health and Human Services included 20 contraceptives as part of its minimum essential coverage that all insurance plans had to have to satisfy the Obamacare employer mandate. Through interpreting that requirement from the legislation, all that the legislation said was you have to cover preventative care. And in the course of interpreting that, they listed 20 contraceptives. Included among those were 4 to which certain religious employers or people who ran businesses, both for-profit and non-profit around the country, objected. These tended to be pills and other devices, IUDs, morning-after pills, that work in part by preventing fertilized eggs from implanting. And people object to this on religious grounds, including David and Barbara Green, the founders and owners of the arts and crafts emporium Hobby Lobby. I've actually never been to a Hobby Lobby, but they consider it part of their Christian duties to provide good health care to their employees, but they also object to these 4 items on the list of 20. But not complying with the mandate would have meant $1.3 million in daily fines. So the Greens, both on their own behalf and through their corporate entity, Hobby Lobby, sued the government, both under the First Amendment, but more importantly, under the Religious Freedom Restoration Act of 1993. Now, RFRA, it's a curious statute. It calls for kind of narrow case-by-case adjudication of religious objections to government actions. It was passed unanimously in the House in 97-3 in the Senate and signed by President Clinton in 93. Its lead sponsors included such right-wing religious zealots as Chuck Schumer, then in the House, and Ted Kennedy in the Senate. And these religious zealots' intent was to reverse a 1990 Supreme Court ruling by that heretical secular humanist Justice Antonin Scalia that approved the constitutionality of generally applicable laws that burden religion so long as that they didn't specifically intend to discriminate against religious people. That is, if objectors wanted an exemption, they would have to seek it from the legislature, not from the courts. Now, when someone makes a RFRA claim, courts are supposed to look at, first, whether the government action at issue actually imposes a significant burden on religious exercise. If it does, then the government must show that it nevertheless is pursuing a compelling interest and is using the least restrictive means of achieving that interest. The burden here is clear. The government didn't even contest that there was a substantial burden on the Greens, on Hobby Lobby. The court ultimately assumed that the government's asserted interest was compelling. And by the way that the federal government litigated this case was curious. It didn't say that there was a compelling interest in free contraceptives or something like that. All they said was public health and gender equality, very kind of broad interests that generally are held to be too vague when you're trying to satisfy what's effectively a strict scrutiny by the courts. And indeed, some lower courts ruled against the government on that basis, that their asserted interest wasn't compelling because too vague. It's kind of like saying, our interest is in good public policy. Nevertheless, the Supreme Court just assumed that that interest was compelling, and so the case came down to that third bit, whether the contraceptive mandate was the least restrictive means of achieving the government's goal. And that's where the government lost, because it simply did not show, could not show, that there was no way to provide free or cheap birth control without burdening believers. For example, the government could pay for the contraceptives itself, or provide tax credits, or make the kind of regulatory accommodations that it offered to nonprofit organizations, some of which are still litigating some of these accommodations. But again, none of these sorts of things were offered to the for-profit businesses. Some of these religious groups, by the way, some of the nonprofits, one of them is called Little Sisters of the Poor. Any of you who are plaintiffs' lawyers or budding plaintiffs' lawyers, I suggest you get them to be your lead plaintiff in any case you file on any subject. So instead, Health and Human Services just chose to continue forcing people to do its bidding. And the court said, you don't have to do that. You can achieve your goal in some other way. So nobody's been denied access to contraceptives. Everyone who's, women can still buy, acquire whatever legal products they could before. And there's now more freedom for all Americans to live their lives how they want without checking their conscience at the office door. Instead, this was just a mandate that was a rights-busting government compulsion that didn't have sufficient justification. Now, before I sit down and end this explanation of a rather simple case, I guess I should address the hubbub about corporate rights. After all, the title of our book and of our event today is Religious Liberties for Corporations, which I really think is an academic exercise regarding how many mandates can dance on the head of a beleaguered citizen. Because after all, as Cato's brief described, it doesn't really matter whether you lawyer up your argument, your claim in terms of the corporation asserting it or the founders, the owners, at least in a closely held corporation certainly, and I guess you could theoretically conceive of a publicly held corporation as well where the interests are all aligned. It's the people whose beliefs that are being impinged or out of whose pocketbook ultimately the fine would be paid. So I think it really doesn't matter. Now, specifically on the legal merits of RFRA, RFRA itself technically applies to all persons, which is a legal term that, unless Congress specifies otherwise, includes non-human entities. But a for-profit corporation can't really exercise religion, can it? I mean, it's kind of ridiculous to apply. It's kind of like applying the term person to a statute about abortion or the death penalty or something like this. It's nonsensical. Well, it's certainly true that Hobby Lobby doesn't pray or have a soul to save. It doesn't even have knees to pray on, right? But it's hard to say it doesn't operate according to certain religious ideals. It closes on Sundays. It doesn't sell shot glasses. It takes out ads in importuning readers to seek Jesus. It refuses to backhaul beer on its trucks. Well, one way that retailers make a lot of profits is when their trucks go out with their merchandise. When they come back, they're empty, but rather than having them empty, they'll haul other stuff, including, most lucratively, beer. But Hobby Lobby does not do that, foregoing considerable profits. But really, neither the profit motive nor the business structure change anything, because modern law, uniformly around the country in every state, lets corporations pursue any lawful purpose. They don't just have to pursue the bottom line. Indeed, corporate social responsibility is a trendy, well, it's been trendy for 10 or 15 years or more. Starbucks, has fair trade coffee, and Chipotle and Whole Foods care about the sourcing of their organic free-range meat, and Google says don't be evil. Lots of organizations, lots of business organizations have all sorts of ethical systems according to which they pursue their mission, and there's nothing really unusual about that, and I don't think that ethical system being religious means that it's subject to less protection. None of these considerations undermine RFRA's solicitude for the rights of humans, including owners, officers, and shareholders. As Justice Alito said for the majority here, protecting the free exercise rights of corporations protects the religious liberty of the humans who own and control these companies. Indeed, associational rights flow from the individual rights of the people who make up the groups to which we attribute those rights, be those groups corporations, partnerships, unions, fraternal organizations, political advocacy groups, a bunch of buddies playing poker. this is not a controversial statement. It didn't even start with Citizens United, right, which freed up independent political speech for all sorts of associations, including corporations and unions. For a long, long time, we have understood that corporations and other associational groups have rights. If they didn't, then the police could storm the offices of IBM and take all their computers, because there's no Fourth Amendment right there. Or the mayor of New York could say he really likes Rockefeller Center and wants to move his office there and can just take it without paying just compensation in violation of the Fifth Amendment. So corporate structure really doesn't matter. It seems kind of odd to say that, as an LLC or a partnership or however other way you can pursue a profit, it's okay. But once you incorporate, for some reason, there's a magical switch where you lose your certain rights. Nor does profit motive matter. Of course, we have Jewish and Muslim butchers who pursue their profit motive according to religious beliefs. Indeed, one of the co-plaintiffs of Hobby Lobby was a Christian bookstore. They're in it to make a buck, Mardel Books is, but they're selling exclusively Christian literature. So let's put this corporations aren't people misdirection to rest. At least for closely held companies, if you pierce their corporate veils, it's their owners who will bleed. I share the practical skepticism that a publicly traded company, a Fortune 500 company, say, could align all of its stakeholders' beliefs to assert a RFRA claim. But in theory, it's possible. If Hobby Lobby went public tomorrow and in all of its SEC prospectuses and investor memoranda and so forth, it laid out clearly how it pursued its business, wasn't defrauding anyone, I don't suppose there would be anything wrong with that. Here, the First Amendment protects free speech, free exercise, not certain speakers, here or in the Citizens United context, and people don't lose their rights, First Amendment, RFRA, or otherwise, when they get together. But the larger conclusion to draw here, and this is getting to what Roger said he was hopeful that we'd get to, is that the essence of freedom is that government can't willy-nilly force people to do things that violate their consciences. Now, some may argue that there's a conflict here between religious freedom and women's freedom or women's rights, but that's a false choice, as the president likes to say. Without this rule, again, women are still free to obtain contraceptives, abortions, and whatever else isn't illegal. They just can't force their employer to pay for it. And if Hobby Lobby's employees were all of a sudden not having access to contraceptives, I think we would have heard about it by now. Moreover, while the focus of the contraceptive mandate cases is the intersection of corporate rights and religious liberties, there's a bigger issue here. This is just the latest example of the difficulties inherent in turning healthcare, or increasingly our economy more broadly, over to the government. When something is socialized or treated as a public utility, we're forced to fight for every carve-out of liberty, as Roger himself has written during this debate. The more government controls, whether healthcare, education, or even marriage, the greater the battles over conflicting values. I call this process hobby lobbification, and I'll be writing about it more in coming months. With certain things, such as national defense or basic infrastructure and other real public goods, we largely agree, at least inside reasonable margins. But we have vast disagreements about social programs, economic regulation, and so much else that government now dominates at the expense of individual liberty. So those who supported Hobby Lobby before the court are rightly concerned that people are being forced to do what their religious beliefs prohibit. But that all comes with the collectivized territory.